estates in the state of Tennessee. Now, estates are an area of the law where lawyers are at their most annoying because there are all sorts of words that are the parlance of estates that aren't used at any other point in anyone's lives. So when I say things like bequest, devise, decedent, intestacy, understand I'm really not trying to be fancy. That's just the words that we use. So for your particular estate, you want to make a plan for your passing because the unfortunate reality is none of us are going to live forever. If you don't have a will in this state and you pass away, the state's intestacy statute is going to control. Now, if you look that statute up, you may be pleasantly surprised because it is something the government of the state of Tennessee has done, which they've done a pretty reasonable job with, and that most people would be happy with. It's going to say, here's what happens to someone who dies without a will's stuff. It's going to go to their spouse and kids, or if their spouse and kids aren't alive or they don't have a spouse and kids, here are the next people in the line we're going to look to take their estate. But let's say that while that's largely good for you, you would be happy with your spouse taking everything or your kids taking everything. There are specific items you want to leave, right? You have an old belt buckle that you want to leave to your cousin. You can do that as well, but for that to be accomplished, you are going to have to leave behind a will. That's a written instrument that describes your testamentary intent, which is to say what it is you want to have happen with all your stuff. Now, that document can be as complex or as simple as you want it to be. It could be sort of what I just described. Here is this belt buckle. This is who I want to leave it to. This is that person's last known address. The end. Okay? Now, the nice thing about a will is it allows you to waive all sorts of hassles for whoever you appoint as your executor. You don't want your executor to have to make an accounting of your entire estate. You can waive that. All right? You want to have multiple executors, backup executors, so that if you do pass, you know who's going to be in charge. And sort of most importantly, you can appoint someone as your executor who you know while you're alive and who you can describe the plans of your estate with, so you can be confident that they are going to execute your will faithfully. Now, last wills are not the only thing you can do with respect to an estate. Okay, you can create trusts. Which are more complex documents, which you'd want to go into on a sort of case-by-case basis. You can also create a living will, healthcare directives, powers of attorney, where you say that if I become mentally incapacitated, this is what I want to have happen. Or if I am in fact incapacitated, I would or would not like to be kept alive. Okay, this is who I appoint to have that decision-making authority. And while a lot of these scenarios aren't, of course, nice to think about in our spare time, we would much rather be concerned with more pleasant topics of conversation. What I've found, particularly with the case of healthcare directives, is it takes the weight off of the family if those directives exist. It's no longer a question of what should we do. It's merely just we're going to do what this individual's directed us to do. So if you have any sort of estate planning you would like to ask me about, feel free to give me a call. My phone number is 865-269-2524. You can also find more information on my website, www.haines.law, as well as a link to where you can schedule a phone consultation with me. Thank you.